Oh, you spoke. I'm sorry. Yeah.
My lord, please allow me to mention item number 11.
11.
Item 11,
Yes.
my lord. I may be allowed 4 weeks' time to file my counter affidavit. I received a copy just today, this morning.
Mr.
Pakin Wichabo, on behalf of the respondent number 1.
Tapikaro Chabu, learned counsel appearing on behalf of respondent number 1, has prayed for time for filing of his counter affidavit. Mr.
Your Lordship, Y.P. Gupta
Vaikur
for the
Gupta,
appellants.
learned counsel for the appellant is present.
Your
Yes.
Lordship, I also filed the stay petitions.
Uh-huh.
So, I request the Honorable Court to kindly suspend the impugned order till the next returnable day.
Who is appearing for the other? There's only one respondent? Sole respondent?
Two respondents.
Who's the other respondent? State respondent?
I think till now
Let's see.
represented.
Your Lordship, Accountant General.
What is the matter about?
Your Lordship, the respondent, he's an employee of State Bank of India, and he was retired voluntarily since then. And however, after receiving all other benefits, now he's asking for the invalid pension. And that invalid pension is not applicable in the voluntary season retirement, Your Lordship.
Okay, so let's come to the order of the court. Let it, lower court. The operative part which you have asked to be stated. Page
75.
Yes, read the operative part.
Your Lordship, page number 81, paragraph 10. From the above extract, it may be seen that voluntary retirement before attaining 55 years of age on health ground is permissible, subject to employee concerned being examined by a medical board consisting of a civil surgeon, be a specialist relevant to the disease ailment, and the bank's medical officer at local head office, administrative office. The medical board is also required to state whether the employee concerned is permanently incapacitated and hence unfit to continue in service, provided that no disciplinary action is pending or contemplated against the employee. Paragraph 11, from the materials available on record, it is nowhere seen that the bank authorities have initiated any disciplinary proceeding against the petitioner for having been absent since 10/10/2006, although he was suspended from service at the relevant time, but for that a memorandum has been already drawn up on 10/4/2002, reinstating him back into service with certain observation. Paragraph 12. Therefore, upon considering the steps taken by the authorities and having regard that the petitioner had served the bank, this court is of the considered view that the petitioner should be considered for grant of invalid pension as may be permissible under the rules. Accordingly, the respondent bank is directed to constitute a medical board to examine the medical condition of the petitioner in terms of clause 2.6g of the manual within a period of 1 month from the date of receipt of a certified copy of this order. The petitioner will be at liberty to produce all relevant documents at his disposal before the board for consideration of the board. The board should complete the examination within a period of 2 months from the date of its constitution. In the event the board is of the opinion that the petitioner is and was medically unfit for service, the report be placed before the respondent number 2, that is the regional manager, SBI, Dimapur, Nagaland, for decision by the appropriate authority of the bank, so to whether the petitioner can be given invalid pension. Such consideration shall be done by the bank authority expeditiously and preferably within a period of 2 months from the date of receipt of medical board from the board constitute. If the petitioner is found entitled for invalid pension, the same should be accorded to him without delay.
So,
Your Lordship, the concerned employee, he retired from the voluntary season because from since 2006 to 2009, without any intimation, he is absent from the service. Accordingly, the management had issued 3 notices to join the service. However, he preferred not to join. And in 2010, he was voluntarily seasoned from the service. Your Lordship, thereafter, he applied for the gratuity benefit and other benefit. Your Lordship, only in the year 2014, he wrote one representation that he was medically unfit. Your Lordship, the provision says that if you have any medical problem, then you have to intimate the bank, and the bank will constitute one medical board which proceed of the sergeant, civil sergeant, and this.
yes.
However, he has never intimated to the bank, and he preferred to go for the voluntary cessation. Now, your Lordship, he never challenged his retirement also. And now he's, after so many years, he's coming that he was medically unfit. And the Honorable Single Judge Court has given a direction to constitute one board at now. Your Lordship, this case is not for challenging the his retirement.
It's the invalid.
Yes.
Invalid part, isn't it?
Yes, Your Lordship. This is only that whether he is entitled for the invalid pension or not. So, Your Lordship, in the voluntary season retirement, there is no provision for the invalid pension, Your Lordship.
Okay. I think it's appropriate if steps have been taken, it will be difficult, isn't it?
Lordship.
What have we passed? Mr. So-and-so, learned counsel, for the appellant has prayed that till the pending disposal of the appeal, the operation of the impugned judgment dated 27/03/2023, passed in WC number 117 within brackets K/2019, may be stayed till the disposal of the said writ appeal. Anything to mention in that?
I'll leave it to the discretion of the court.
Okay. Which has not been strongly objected by the learned counsel for the respondent number 1.
Yes, ma'am.
1. In view of the above, this court find it fit to stay the operation of the impugned judgment and order dated 27/03/2023, passed by the learned single judge till the disposal of this said writ appeal. This is the matter after 3 weeks for the respondents to file their counter affidavit.
Much obliged, Your Lordship.
Yes.
Please, Your Lordship. Well, look, I beg to mention item number 16, hearing item.
Yes, hearing.
Your Lordship, I have received an instruction, telephonic instruction from Health and Family Department, means responding department, for taking some more time.
Lordship, this matter has been pending since 2019, and only on rare occasions, division benches which can take up the matter is being set up, and now they have come forward after all this when it is in the hearing stage.
But why have they prayed for time? Is there some development going on?
Now, Your Lordship, the thing is, this file has been taken over by myself later part of last year. I have
Okay,
recently
huh.
forwarded a telephonic message that the department is not aware of the appellees of this appeal. So when the department is aware, how can I appear in this behalf? On behalf
Okay,
of the department?
okay.
So I may be allowed to sort out the communication here. I admit the submission of the appellant because of the posture of the bench. It has been pending for such a long period. But if it is allowed, we can take up on virtual also. Because it has, admittedly, it's pending since 2019.
Okay.
But the problem with me is that without the, say, knowledge of.
Yes, you can't
Yes,
represent
I cannot.
unless he's
Yes, I
given
cannot. I
proper
cannot
instructions, yes. On the prayer made by Mr. So-and-so, learned additional AG, the matter may be adjourned since he has yet to receive proper instructions from the state respondents. Mr. Tongor Pungunjan, learned counsel for the appellant, is present and submits that it is difficult to place this matter before the available bench since the appeal is against the judgment and order passed by a single bench. Oh, okay,
Your
leave that,
Lordship,
leave that, leave
yes,
that, huh?
Justice K. Sima cannot
Okay,
take
okay.
matter.
A single bench which often sits in this bench. Okay, I'll correct that little part. Huh?
Your Lordship.
In view of the above, however, considering the submissions made by the learned additional AG, matter may be listed after 3 weeks. Maybe a different bench will be there. Or if required, may be taken up through VC.
Yes, Your Lordship.
If found appropriate.
Yes, the registry may be.
Yeah, by,
Given the direction.
yes, if found appropriate. List after 3 weeks.
Your Lordship.
Judicial, my lord, you may seek the indulgence of this honorable court. Your Lord, item number 13. Item number 13, this is for hearing, judicial, but there is another matter which is there ahead of us, and that is ready for hearing. If we can pray that this matter be fixed on the 1st of November. The counsel for the PP is also, the NIA is also here,
Okay. So on the submission
on both sides.
made by the learned counsels of both the parties, this matter may be fixed on
1st November.
1st November 2023. Yes.
May I please, Lordships? My Lord, I beg to mention item number 17 and 18. 17
Yes.
and 18. My Lord, here, I am for the appellant in item number 17. We have a consensus prayer to list the matter after 2 weeks, my Lord.
Okay. On the submission made by the counsels for both the parties, matter to be listed after 2 weeks.
Much obliged.
The earlier mention which I was making, Your Lordship, both 13 and 14. 13 and 14.
Yes, it's 13 and 14, yes.
Your Lordships, I'd like to mention item number 1. On behalf of V. Socrates, Additional Advocate General. Since she's unwell, we pray that the matter be listed after 2 weeks.
Okay. On the submission made on behalf of the learned Advocate General appearing for the applicant / appellant, matter may be adjourned for 1 week.
For
2
2
weeks.
weeks.
For 2 weeks. List after 2 weeks.
Your Lordship, I'd also like to mention item 20, similar prayer.
Yes, okay. On behalf of V. Shokre, okay, learned additional AG.
Your Lordship, one more item, item 9 from the orders. On behalf of the AG, since he is engaged in the Supreme Court, we pray that the.
Who's the present AG now?
Balgopal.
Okay, Balgopalan.
The matter may be listed after 3 weeks.
Okay, on the prayer made on behalf of the learned AG for adjournment of the matter, list the matter after 3 weeks.
Obliged.
May I please, Lordships? My Lord, I'd like to mention item number 5, 6, and 7.
Yes.
5, 6, and 7. My Lord, here in item number 5, I'm yet to file my affidavit in reply. If I may be allowed another 2 weeks time, my Lord.
Okay, Mr. Ezo Takakichu, learned counsel for the petitioner, has prayed for further time for filing of his reply to the counter affidavit filed by the respondents.
2, 4, and 5.
Respondents number 2 and 4 and 5. Praise aloud. List the matter after 2 weeks. 2 weeks.
Much obliged.
May I please the Lordship? Lordship, I'd like to mention item 19, Lordship. Hearing matter item 19.
Yes.
On behalf of my colleague E.T. Bapom, Lordship, for the state respondent. Lordship, if this matter can come up after 1 week, Lordship.
On the prayer made by Mr. So-and-so on behalf of his colleague, Mr.
E.T. Bapom.
Itapokong, learned government advocate, appearing for responding, the state respondents. Matter may be adjourned for 1 week. You want your name reflected, Mr.
Limo Bangchi.
Imo Bangcho appears on behalf of the appellant,
For respondent number 4.
along with Mr.
Respondent number 4.
Okay. Mugaka, is it? Learned counsel for respondent number 4. List the matter after 1
So
week.
after 1 week, next week.
After 1 week.
Lordship, I have similar prayer for item 21, Lordship, on behalf of E.T. Bapom.
Item number
21.
21. Okay. Same. Only thing is, Mr. Inti Tilong appears on behalf of the appellant.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 8 on behalf of Mr. Adil Ahmed. The leading counsel is from Gauhati. So, kindly list the matter on 18 October.
Miss
Clear.
Tiakri, learned government advocate, prays that this matter may be listed on 18th. 18th, 9, yes, 18/9 so and so. 18th, it will be 18th what, October? 18/10. Since the leading counsel is an outstation counsel and is not able to appear today. Accordingly, this is matter on 18/10 so and so.
For motion, item number 2. Item number 2 and 3.
May I please, Your Lordships? Lordship, this present IA has been filed praying for consolidation of delay of 478 days in filing the connected rate appeal. Lordship, I have stated the reasons for delay in paragraph 2 of page number 4. Lordships have got it.
Yes.
If I may read, Your Lordship. That the applicant respectfully states that there is a delay of 478 days in filing the said writ appeal. However, the said delay is neither intentional nor due to negligence nor lapses on the part of the applicant, but because of the facts and circumstances as stated herein below. Lordship, A, that the writ petition number such and such, along with 2 other connected matters, was finally heard on 8/3/2022, and the learned single judge was pleased to reserve the judgment and kept the matter CAB. That subsequently, the learned single judge, by a common judgment and order dated 11/8/2022, was pleased to dismiss the writ petition. That the applicant was not aware of passing of the said judgment and order dated 11/8/2022 and the applicant was not informed by the council that the applicant came to know about passing of the judgment and order dated 11/8/2022 only through other sources, and immediately on 6/8/2023, the applicant approached the learned counsel and collected the relevant file.
Okay, fine. That is your main reason because you didn't know about the judgment. Will you show notice?
Lordship.
Pardon, Mr.
I, Jamil.
I, Zamir, learned counsel for the applicant/appellant who has filed this application under Rule 2 within brackets 2 of Chapter Roman 5-A Gauhati High Court Rules, praying for the condonation of delay of 478 days in filing the writ appeal. Issue notice to the respondents through registered, anyone appearing? To the respondents, Mr.
Mosam, no comment.
Mosam Lomkamar, learned government advocate, accepts notice on behalf of the state respondents. Any private respondents?
Lordship, respondent number 7.
Notice be issued to the private respondent number 7 through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks. Copy of the IA to be duly furnished to the learned government advocate. Yes.
Much obliged.
For admission, item number 4.
Your Ladyship,
Yes.
in this case, there has been some developments after the filing of the petition.
Okay.
So we will be given 2 weeks' time to file an additional affidavit.
What's up of development? What sort of development is there?
Your Lordship, the review which was pending, that has been disposed of. Some directions have been issued there. Then the civil suit has been filed. And in the civil suit, some pleadings have been exchanged between the parties. So those pleadings, these developments have a bearing on this contempt petition, Your Ladyship.
Okay, so you're going to pray for filing of an additional affidavit by way of an IA, most probably.
Just additional affidavit.
Okay, you want to file, which is not going to be objected. Okay. Okay. Okay.
I'll see whether I can file the plan.
Okay. Heard, Mr. So and so, learned counsel for the petitioner who has submitted that since there are certain recent developments in connection with the matter, he may be allowed to file an additional affidavit. Mr. C.T. Zamir, learned senior counsel, is present and has not is present. In view of the above, list this matter after
2 weeks.
2 weeks.
Much obliged.
For admission, item number 10.
May it please your lordships.
Yes.
My lords, the IA number 4 of 2023 has been kept pending for a very long time. And my lord, the reason being that this being a conviction under POCSO Act, it appears the Honorable Court has also been having some apprehension or some caution not to take up this issue urgently. But I believe the reports have also come, your lordships.
Yes.
Now the appellant's case is that he has been wrongly accused of raping a minor. And if I take the lordships to the annexures, the statements, starting from statement under section 164, the medical record, and the statements during evidence, my lords will appreciate the fact that this judgment and order dated 13/3/2020.
Now we are going to deal with the connected IA, is it? Now with the IA is not here? Yes.
Yes. The IA is for suspension of the judgment dated 13/3/2023 and order dated 15/3/2023.
Yes.
Now may I take the lordships to the medical reports. The medical report of the victim is at Annexure 3, page 41, page 41.
Page 41, we are dealing with the IA, isn't it?
Yes, no, your lordship, the annexures, I'm relying on the main petition, the main appeal petition, my apologies, my lords.
Yes.
May I take your lordships to the relevant page, that is page 42. The last Roman 5, injuries on body. The last part. Injuries on body. Body charts may be used for recording the injuries described, name, type, site, dimensions, color, margins, etc. of the injury. If necessary, use separate sheet. Head, neck, face, no injury marks visible. No injury mark visible. Then, may I take your lordships to the next page. Roman 6. Local examination of genitals, anus, and oral
Now, before
activity.
we really go ahead,
Yes.
now, in this case, the informant, is she being represented as respondent number 2?
Yes.
Were they? Okay, fine. Yes, go
Your
ahead.
lordships. May I take your lordships to page 43.
Yes.
The Roman 6. Local examination of genitals, anus, and oral cavity. Following areas may be examined for evidence of infection, matting, staining, redness, swelling, edema, bleeding, bruise, tears, abrasions, etc. Relevant samples should be collected before commencement of local examination. A. No. Labia majora intact, labia minora intact, clitoris intact, foreshaded introduced, vagina intact, hymen, no visible tear, EO, perineal tear if any, no, urethra, intact, anus intact.
Just wait.
Yes.
Just
It shouldn't be live stream. So have they removed it? Okay, it's clear. We'll tell them not to live stream it first. Yeah.
My lord.
Have they removed it?
No, it's okay.
It's okay. Just do not live stream it. That's all.
Oh, for that matter, your lordships, names are all XYZ, so,
But even then,
my lords.
yes.
My lords.
Yes, go ahead.
Now, as far as the medical examination is concerned, no injury, no tears, everything intact.
Yes.
Now, that is the medical examination. Now, coming to the medical examination of the accused appellant also at page 34, your lordships. Page 35 is a typed copy of page 34.
Yes.
This is the accused person, the appellant. The examiner was brought to hospital with the alleged complaint of committing rape on minor. At present, there is no health issue. Now,
This is concerning the
accused.
accused. Huh.
The accused. So as far as the medical examination of the accused is also concerned, everything was found to be normal. Now, under a normal circumstance, your lordships, live streaming is over. Okay. In that case, if my lords may kindly allow me to elaborate a little further. Now, when an accused person, a man is accused of raping a minor, it's not just the minor who will suffer some injuries in
Yes. What is this appeal
Yeah,
about?
Mr. Lordship, this is with regards to payment to the appellant for a contract executed by his firm. Now, Lordship, the issue here is, may I, at the outset, just the crux of the matter. I was awarded a contract in the year 2005. It was initially for a period of the work had to be completed within a period of 1 year. However, because of some problems beyond the control of the parties, insurgencies, people were kidnapped, insurgents had come and camped on the side, road conditions and all that, it got extended, prolonged, and the work finally completed in the year 2013. I was unable to complete one component of the original work that has not been completed, but that is not the issue here. The original work is not the issue here. In the year 2012, I was given some additional works. Now, in 2005, when the contract was awarded to me, Lordships, I had signed an contract agreement. Now, the bill of quantities, the rate that I had quoted, that I will execute all the works in accordance with the rate mentioned in the contract executed in the year 2005. That clause was there. That's undisputed. That clause is there. I admit that that particular clause is a part of the contract agreement. However, some additional work was required because of the site requirement, and that was forwarded to the sponsoring authority by the respondent number 3, who is respondent number 2. Respondent number 2 is NVS, Navodaya Vidyalaya Samiti, and they wanted to construct a JNV school, Jawahar Navodaya Vidyalaya School at Chare. Chare is in the district of Tuisa. It's a place. So respondent number 3 is a government of India undertaking. They execute all these works, and respondent number 3 floated the contract, and I got the contract in the year 2005. Now, some additional work came about in 2010 that was forwarded to the respondent number 3, the sponsoring authority, approved the rate, the amount, the money was also sanctioned in the year 2011, and I was told to execute it in the year 2012. So, I have executed the additional work, 3 additional works. I've completed it, but I've been paid a very small amount in terms of the contract agreement, the rate mentioned in the year 2005. For the work which was given to me in 2012, executed in the year 2012.
Additional work in 2012. So the rate was as per the 2005.
Now the issue is, they're saying that it is the contention of the state that since you have signed the contract, you have agreed that you will do all future work in terms of the rate mentioned in the 2005. You cannot claim the additional rate. You cannot claim the rate which was approved by respondent number 2, the sponsoring authority, NBS.
Okay.
So that is the issue. My case is, yes, it's admitted that there's a particular clause in the contract agreement which says all future work, additional work also will be executed in terms of this rate. But whether such contract or such clause in a contract is enforceable, because it's unfair, it's irrational, it's unconscionable. An unconscionable contract or term of a contract is not enforceable in law and is hit by Section 33 of the Contract Act. Therefore, even if I have agreed, such term will not be enforceable in law. That was my case before the learned single judge. During the course of the hearing, they pointed, of course, it is there in their affidavit also, respondent's affidavit. Respondent number 3, 4, and 5 is the principal respondent here. Respondent number 3 is the person who is supposed to pay me.
Are they all present today?
Yes,
They're
they're
all
all here,
present?
they're all
Okay,
here.
yes.
Now, they rely on a clause which deals with the jurisdiction of the court. Lordship, I'll be pointing that out, I'll come to that. So it says only courts in Delhi will have the jurisdiction to hear any matter.
Through arbitration? No.
Pardon?
Is it wide arbitration? No.
No, it's not an arbitration clause. And
Okay.
Respectfully, the learned single judge, it is not an arbitration clause, but the learned single judge has dealt with that clause as if it's an arbitration clause, and therefore directed that the arbitration proceeding has to be completed before we approach under Article 226. My case was, Mama, that provides for a jurisdiction, and yes, the party can enter into a contract, an agreement, and oust the jurisdiction of a court, of a court. If there was if the cause of action is arising in Delhi as well as in Nagaland, the party can consent and oust the jurisdiction of the courts in Nagaland. But when it comes to writ petition, when it comes to writ under Article 226, the jurisdiction of the writ court cannot be ousted even by consent by the parties. That was my case. This is an extraordinary jurisdiction, and therefore this power of the High Court, of the Honorable High Court under Article 226 cannot be even ousted by consent of the parties. That was my case. But that clause has been interpreted as an clause for arbitration, which is absolutely incorrect. And secondly, the learned single judge also has held that the facts are disputed question of facts, therefore the court cannot adjudicate the matter, cannot decide the matter. Insofar as the completion of the additional work is concerned, I also admitted that insofar as the original work is concerned, I have not finished one component, that is kitchen and dining hall. I have made categorical statement, and subsequently my contract has been terminated. I have not been able to complete that part. But additional work I've completed, for that additional work, I've been paid 21,55,322. That was paid to me in January 2012.
Okay, so for the additional work which you said you have completed, it's not disputed?
It has not been disputed. They have not, I mentioned it, they have not said that this additional work particularly, they have not rebutted that I have not completed the additional work. They just generally have not completed the work. I have not completed the original work, yes.
Which you agree, which is not disputed.
Which is not disputed.
Okay.
But insofar as the additional work, I've made categorical statement, and there's no categorical statement saying that this additional work has not been completed. In fact, I've said that I've received the money. I've been paid, but I've been paid in terms of the original contract, and the respondent number 3 in their affidavit says this has been paid in terms of the contract agreement.
Okay.
So therefore, there's no disputed question of facts. And even in contract matters, the worships are well aware that it is maintainable relating to the, in view of the facts and circumstances of that particular case. Therefore, the learned single judge heard in all these points. Now, Lordship, may I take your Lordship to the, to the facts first? Lordship, may I kindly come to page 78. Lordship, this is the tender notice. Lordship, this is dated on page 78, initial. This is dated, it was opened on, it was slotted on 17/2/2005. Name of the work is Construction of Phase A, Package 2 Building for JNB at Chare, District Tucson. Approximate cost is rupees 217.25 lakhs. All of this is relevant here. May we go to the next document? That is page 82. Here Here, Lordship, here, may kindly come to the type copy that is at page 84. And here, this is one of the documents, contract documents, which includes the tender documents, and which also provides the scope of work at page 85. This is the original work. The original work included school building, kitchen and tiling, external development works, which includes construction of underground tanks, tube wells, drainage system, road work, open surface drains, internal and external electrical works. So this were the original work. Here I have not been able to complete the second one, that is kitchen and dining. And finally, during the pendency of the lead petition, my contract was terminated in 2014, 15, and thereafter it was revoked again. But I have not been able to complete this kitchen and dining. During the pendency of the lead petition, the contract again was terminated. But, Lorships, I have completed the additional work way back in 2012, 13. I have also been paid, but not the amount as per the reverse rate. Now, Lordship, may kindly come to the award of contract that is at page 86. This is the letter of award dated 25/2005, page 86. Then Lordship, may kindly come to page 89. Lordship, since these issues are not very important, I'm just highlighting your Lordship through the documents only. And I'll stress only where it is relevant. Lordship, 89. This is the agreement which I have to execute pursuant to and the entire agreement is the agreement contains several documents, which is very bulky, but I've just enclosed this. If required, Lordship, I will furnish it.
Okay, now
this was executed on 22/8/2005.
So does this include the jurisdiction matter which you just
Lordship,
mentioned?
that is a separate part. It's here. I'll
okay, you have not come to that.
Yes, we have not come to that.
Okay.
No, but this is a part of the agreement. This documents, that clause, jurisdiction clause also was an annexure to this contract agreement. Therefore, on signing of this contract agreement, they are saying that I'm bound by the jurisdiction clause too. Lordship, it starts here, page 91. The letter dated 25/11/2010, written by respondent number 3 to respondent number 2. By officials of respondent number 3 to official of respondent number 2. May I read this?
Yes.
Construction phase, the phase of building of Johor Normatia Vidyalaya District Tourism. Reference letter number such dated 30/7/2010. Yes, sir. As desired and close find herewith modified RPE, that is revised preliminary estimate incorporating all cost details essentially required for completion of the subject work as well as additional work desired by the principal GMB Tunsan. As the work at site is in full swing, it is requested to kindly accord approval of the RPE so that work at site can be carried out smoothly. So a proposal was submitted, which also included the proposal for additional work.
Okay, this is in 2000?
This is dated 25/11/2010. Lorships, may kindly come to page 92 now. This is the important letter by the respondent number 2. Lordship, this is dated 29. Below handwritten is 29. Atop the right hand side, 26/9/2011, and with hand they have written 29. So it's referred to as the letter dated 29/9/2011. So this is by respondent number 2 to the officials of respondent number 3. May I read this? The revised preliminary estimate for the above works submitted by letter under reference has been examined and I'm directed to convey revised such and such amounting to rupees 1,310.93 lakhs against the revised such and such of rupees 937.36 lakhs dated 16/5/2005, accorded by the committee earlier, as per details given in the annexure. The construction agency is required to complete the work in all respect within the revised sanction amount and stipulated period and submit the final settlement account in the prescribed format along with details. So this is the sanction letter. By this, even the money required for the additional work was also sanctioned by the respondent number 2, responsible authority. So there's no shortage. The fund was there. The fund was given. They have said it in the affidavit with all this. It is also mentioned in the affidavit that we have given the money, we have sanctioned the money. And respondent number 2 says, I'm not a necessary party. I've given the money. It is the respondent number 3 and the contractor, the contractor. Now, Lordship, when you come to page 93, the additional work which I have executed are item 10, HCL number 10, 11, and 12. Boundary fencing, boundary wall fencing, one is shown as 42.46 lakhs. These are in lakhs, Lorships. So boundary wall fencing, 42.46, retaining play field, number 10 play field, 36.02, boundary wall fencing, 42.46, retaining wall, 96.22. All in lakhs. So this was the money sanction for the additional work, and these are the works which I've executed and for which I've been paid very less in terms of 2005. I'm claiming that I should be paid in terms of this approval, in terms of this revised rate.
Okay, so what is the total amount for these 3 works?
3 works total. Actually, 36 is 36.02. 36.02. 42.46. 96.2. 42.46. 36.02.
174.
So 174 is the amount which you are claiming now.
174.1.
This is the amount you're claiming from the respondents.
Yes, this is their own.
Okay. Okay, fine.
After this, Lorships, mechanically come to page 94. I was informed, my firm was informed by this letter, 6/1/2012. Dear sir, this is to inform you that NBS white letter number such, dated 29/9/11, has approved the revised cost of the work. Copy of the same is being forwarded to you. Also for your reference and record, you are hereby advised to expedite the completion of the work. An extension on account of non-approval of revised cost shall an extension on account of non-approval of revised cost shall be entertained. You are also advised not to execute any work beyond the cost approved by NVS without prior approval of rights. So, Your Honor, this is, Your Honor, mechanically note the date 6/1/2012. It's only in 6/1/2012 that I'm told to execute the additional works. This works in terms of the approval given in 2011 by NVS. This is not a part of the original work, additional works. Therefore,
Wait, NVS is respondent number?
2.
2, okay. Yes.
After this, page 95 is an email letter by one official, senior official, to the other official saying, directing him to show me the work. 96, page 96. By this letter, this is dated 21/2012. I was also given the instruction regarding one of the component of the additional work, that is the retaining walls. So this is also not very important. These are not disputed. And these are summaries of the additional work. Abstract summary for the construction of the additional work, which includes boundary fencing, and page 98 is the play field. We can skip this also. After
Yes.
this, Lordship, page 99. 2005 contract given to me, but till 2013 I could not finish some of the original work, one component of the original work, and therefore an additional work I had done. My contract was terminated. by
Because of the
letter-
kitchen and
Dining
because,
and kitchen. Dining and
okay.
kitchen. So this is by letter dated 12/8/2013. The contract, original contract, my entire contract was terminated. Then Lordship, type copy is at 101, page 101. And this letter, the other mechanic Lordship mechanic come to page 101. Clause number 3, paragraph 3, 101.
Yes.
You are accordingly, after termination of the contract, clause 1 says your contract is terminated, clause 3 says you are accordingly requested to report to such and such at GNB Tuisan, Netherlands, site office in person or through an accredited representative at 10 a.m. on 31/8/2013, where an inventory of complete work will be made and recorded jointly. In the event of your failure to keep up this appointment, inventory will nevertheless be prepared, notwithstanding your absence, and the same shall be final and fully binding on you. So, after the termination of the contract, I was supposed to go to Tuisan, and in my presence, an inventory had to be prepared of the work completed, the work not completed. And accordingly, if I had to receive something based on that inventory, I was supposed to pay. Accordingly, I went and prepared the inventory, and I was, as per the inventory, I was to be paid rupees 23,78,174. 23,78,174 rupees. That is for the original work. Additional work I've already been paid by them.
Wait, from where are you reading that figure?
Lordship, I'm not. Lordship.
This 23 lakhs from...
Yes, Lordship, that I have not come to that. I'll be referring to that.
Okay. It's not here where you're
Yes, it's
showing
not
us. Okay.
Then what happened is that they issued this letter at page number 103. By this letter that 103, by this letter dated 29/3/16, a demand was made. A demand of rupees 2,18 lakhs was made. 2,18 lakhs 60,493. This was for the security deposit and expenses to be incurred for the incomplete works. According to this letter, it also includes the security deposit that I had to be made, and also the expenditure that will be incurred by respondent number 3 for the work which have not completed. So,
the original
work.
Okay.
Because the only work that was left incomplete was the original work, kitchen and dining. So this demand was made. So therefore, I approached this honorable court. I approached this honorable court challenging this letter, challenging this letter as well as the termination order. But here, Lordship, page 104, the writ was, at that point of time, the issue was not raised that this honorable court does not have the jurisdiction to entertain the writ. That stand was not taken earlier.
Okay.
In this writ, at 104. They never took the key of saying that this is not maintainable because of the clause in the contract of the jurisdiction of this court.
Where is the counter affidavit, a copy of the counter affidavit filed by the respondents? Okay. So you're saying in the counter affidavit...
This judgment 104.
Okay, this is a different judgment. Okay, fine.
So, yes. So here, they never took the stand here, previous occasion. This was filed in 2016. They never said that this petition is not maintainable because of the jurisdiction clause in the contract agreement. But this time they took that.
Okay.
So, by this judgment, which is dated 30/8/2016, this honorable court directed that, as per the inventory, relevant portion is at page 111. As per the order dated The letter dated, which was that? 29. Ah. Yes. This Honorable Court directed that as per the inventory prepared, I had to get an amount of rupees 23,78,174. So the respondent number 3 was directed to pay this amount. And regarding the termination, page 111. Regarding the termination of the contract and also the that was challenged in a civil suit filed in Tucson. So, regarding the termination of the contract, this Honorable Court said that let that be decided in a civil suit.
Yes, termination of the contract.
Yes, termination of the contract, let it be decided
Oh,
in the civil suit which is pending, because it is also being challenged there. But here, direction was given only to pay the amount which I was supposed to receive for the all original work in terms of the inventory prepared. May I read the relevant portion?
Oh, so you had approached the court also. This is a separate case where you had approached the court, is it?
Yes, yes. This is regarding, I had challenged the letter dated 29/3/16 and the termination letter dated 12/8/2013.
Okay.
And yes, page
Okay,
99
so
and
you had
103.
another case before.
Before.
Okay.
Page 99 and 103. These are the two letters which were challenged here. And so this was the direction given. We will not interfere with the termination of the contract because that's the subject matter of the suit. Let it be adjudicated there. Insofar as the money that they have demanded. Instead, this Honorable Court said that now, as per the inventory, I am the one who's supposed to receive certain amount of money, which is 23,78,174. So the respondent number 3 there was given the direction to pay me this sum.
Okay.
They are well in appeal against this judgment. But during the pendency of the appeal, the parties got into an agreement and decided to withdraw all the cases and even the appeal. So they also withdrew the appeal. I also withdrew the civil suit, and the termination of the contract was also revoked.
Okay. So you could again continue your works, is
I
it?
could continue my work, but again, Lordship, I was not able to complete it because it became very difficult for me to work at the rate which was fixed in the year 2005.
So the kitchen and dining has been pending, huh?
Yes, that is. Even hostels, the hostel building was given to some other contractor. Even they abandoned it. The school building, everything I completed, and it got inaugurated sometime in the year 2013. Kitchen and dining I could not complete. Now, Lordship may kindly come to page 112. Now, this is the bank statement, and they have not denied this document, and they have not denied that they have received this amount for the additional work. 112. Lordship may kindly come to 1, 2, 3, 4, 5, 6, 7, 8, 7, the date. 2/1/13. 2/1/13. The date 2/1/13. 2/1/13 on the top. 1, 2, 3, 4, 5, 6, 7, 8. The transaction.
Yes.
2/1/2013. And then the amount that was credited in my account is 21,59,322. This is the money which was deposited in my account by the respondent number 3 for the additional work that I had completed. This is the payment given to me.
Okay.
There's no denial that about this, I have made categorical statement that I have completed the additional work and this is the amount that has been paid to me. They have not rebutted it. So this was paid way back on 2nd January 2013. After this, I started sometime in 2016. This letter dated at page 113 is the first letter writing to them saying on 30th 5 2016, demanding that I should be paid for the additional work, the rate which was approved by the respondent number 2 in the year 2011, the revised rate.
Okay, after receiving this 21
Yes,
lakhs,
yes.
now you want some more money.
I wanted money.
Okay,
I said that
okay.
I should be paid in terms of the revised rate.
Revised rate was how much?
Revised rate is given, or it came to total 1 lakh, 1%.
Yes, yes. So you wanted that.
Yes.
You found that this 21 lakhs was less.
Yes.
Okay.
I started writing to them. Then, Your Honor, the Lordship may kindly come to page 114, type copy as 114.
Why you have waited for 3 years?
Yes, Lordship. That he has done. Examination of contract and all that was going on, litigation was going on, civil suit was going on, civil suit also withdrawn. Yes, there was lectures on that part, yes.
Civil suit was
Withdrawn.
regarding combination. What was this?
It was a civil suit termination of the contract. Additional also regarding the payment of additional works. That also was a part of the issue.
There has also been withdrawn.
Everything withdrawn because of the settlement which has arrived subsequently. I'll come to that also. There are certain documents here. Lordship, that will come. I'll be placing those documents also. Now, 16 years. Yes.
Very, very long. Anyways, he has not really come to the crux of the case where the single judge. That we have not come to that yet. It's just on the background. We are still coming to the background. We have not really touched the matter also. Yes.
So, Lordship may kindly come to page 150. The rate.
Yes, page
115, type copy. This is the stand which they have taken for paying me in the old rate, the lesser amount, dated 5/5/2016. In 2016, they said. May I read this?
Yes,
yes, sir. Kindly refer to your letter number such and such, dated 29/3/16, which has been issued in accordance with clause 3, section 2 of the contract agreement signed by you, and thus it cannot be called an afterthought. You also note that the rate of additional items in final bills have been considered on mutual agreement terms and conditions between rights and your company, for which you have submitted unconditional no claim certificates to rights. So they have referred to also one NOC. They said that it's in terms of the contract agreement, terms and condition of the contract agreement, and then they said that you have also submitted an NOC. NOC is I've made categorical statement, they have not also rebutted that. So therefore, pleadings also become very important here. I said NOC was given only for the original works, not for the additional work, but for the amount which I had received pursuant to the inventory prepared.
Okay.
That's the come to page 17. I also received. I asked for the rate to be revised for the additional work by this letter dated, which is at Annexure 17, page 116. The response, Lordship, is at page 117. Letter dated 3/6/2016. May I read this?
Yes.
This has reference to your letter dated 34/16, by which the rate of additional items have been objected by you. You may kindly note that the rate of the additional items undertaken by you have been given strictly in accordance with clause 12.1.2 under section 2 of the contract agreement signed between Rights and your company. While working out, the total cost of work done by you has been examined and no ambiguity found therein. A copy of clarifications sought from the concerned offices and enclosed for your reference. So, they said, this is in terms of the agreement clause, contract clause. Therefore, your bill has been paid in terms of the contract agreement signed by you. And they've also given the clarification, which is at page 118, the next page.
This is the 2005.
2000. This is just a clarification, 118.
Okay. This is not the agreement.
This is not the agreement.
Okay.
We'll come to that.
Okay.
Lordship, may kindly see, in reference to your subject and work and your email dated such and such, the following points are put up for your kind perusal. Determination of rate of additional work is done as per clause 12.1.2 of the contract agreement at page 152, which state as follows. Rates, clause 12.1.2. Rates for such ordered additional or substituted items of work shall be determined by the engineer-in-chief as follows. If the rate for the altered, additional, or substitute item of work is specified in the schedule of quantities, the contractor shall carry out the altered, additional, or substitute items at the same rate. This is where they're stressing. This is where they're saying that I'm bound by this, at the same rate. If the rate for the altered, additional, substitute item of the work is not specified in the schedule of quantities, the rate of the item shall be derived from the rate for the nearest similar item specified therein. If the rate for the altered, additional, or substitute item of the work cannot be determined in the manner specified in subparagraph 1 and 2 above, such item of work shall be carried out at the rate entered in the DSR, Daily Schedule of Rates, DSR. Daily Schedule of Rate 1997, plus minus the percentage quoted by the contractor against the cost of civil work based on the DSR 1997 in BOQ. The work was executed as additional items. Lordship may kindly note, the work was executed, is completed, executed as additional items, which includes retaining walls, playfield, boundary fencing works, measurement of which was entered in the bill as extra items number 9 up to 22. All these items exist either in BOQ of the contract agreement or in the DSR 1997 as presented in Annex 1. The items of subject contract is based on DSR 1997. Hence, rates of all these extra additional items have been arrived by adding 104% as quoted by the contractor in the contract agreement above the rates of DSR 1997. The measurements of the items have been reviewed and advised and no shortfall has been observed. Therefore, the stand is that I quoted 104% above the DSR 1997 while quoting for the contract in the year 2005. And therefore, this additional work also has been prepared, the rate has been prepared, the rate has been given, all these additional works rates have been mentioned in the 2005 BOQ. So therefore, I'm entitled to only 104% above the 1997 DSR, Daily Schedule of Rates. And therefore, this is the amount that I'm supposed to get, and they paid me the amount. I cannot claim that revised rate, even though approved by the NBS, the respondent number 2, because I've signed the agreement. And Lordship, they don't deny that I've not executed the work. They said I've executed the work. And only thing is that I've got
the rate is, they're saying the rate is high, that's what you're saying.
I cannot claim the reverse rate. I've agreed to it now. I'm bound by the contract. That is the issue. Actually, that is the issue. The issue is very limited. It's only question of law here. This honorable court has to decide the law here. Which is it enforceable? Such a contract is enforceable or not? Factually, they have already admitted it. Even before approaching this honorable court, the facts are admitted. They have admitted that additional work he has done. We have paid you, but we have paid you in terms of the contract, so you cannot claim the new reverse rate. They admitted. And finally, we ended up here before this honorable court, say that no, that term cannot be enforced. But there has been, in fact, the judgment is perverse in the sense that it's totally factually incorrect. And this was not the pleadings, these were not the pleadings also.
So come to the part of the judgment.
May I again?
Yes, before that, what do you want to point out?
18, 19, section 2. 120.
Okay.
120 is the portion where this clause 12.1.2 is given, page 121. So this is the clause, page 121, clause 12.1.2, which have already been quoted earlier. Lashes had read that. So this is the particular clause, clause 12.1.2, clause 1. So as per this, I'm entitled to be paid at the same rate, even for additional work. That's what they say. So they are relying on this clause. Now, yes. Then, during the pendency of the appeal and the civil suit, Lordship, I was approached. I was asked to write a letter requesting for a settlement. You write a letter requesting for a settlement, we'll also withdraw the appeal, you also withdraw the civil suit, and we'll revoke the contract and you continue with the work. And we'll also review the payment of your additional work. And accordingly, I wrote this letter at page 125.
So the terms of your agreement, is it in writing? You came to an agreement, you say.
Yes,
so
the supplementary agreement is there, but there's not
the agreement is there?
But it does not mention much. They won't issue the letter. After this, 125, page 125, that is the request that I had to make so that they could revoke the contract, revoke the cancellation of the contract, and withdraw all the cases. This is the letter dated, this is the letter written by me. And Lordship may kindly come to page 125. This is the withdrawal of the suit. I withdrew the suit. Then counsel such and such advocate for the plaintiff and also such and such for the defendant. Counsel for the plaintiff pray for withdrawal of the suit with a view to settle the matter outside the court. So that case was withdrawn. Then, Lordships, page 128. This is the letter revoking the cancellation of the contract. It's dated 7/4/2017. And yes.
Yes.
May I read this? Yes, sir. Rice is pleased to issue the letter of revocation of the contract on terms of the condition of the original contract, in terms of the original contract, number such and such, dated 22/8/2005, signed by you. As per the terms of the settlement or out of court, the following conditions shall be followed. The remaining work of package 2 shall be executed by you as per terms and condition of the original contract signed by you with rights limited. The rest for additional work shall be reviewed. The rest for the additional work shall be reviewed and will be paid as per original contract. So, how should this catch you? It says the rest of the additional work will be reviewed. The rest will be reviewed. And again,
as per the original contract. Yes.
Now, I'm interpreting that it is to be reviewed. Even the rate has to be reviewed. Payment is how it will be paid. Payment is a different thing.
So if it is reviewed as per the original contract,
now,
according to them, it should be not more than 100 and something percent.
Yeah, again, they say
something,
that
140%.
In terms of the contract signed by me, therefore the rate is already mentioned there. So nothing more, you are not supposed to get anything more. My stand was that since this was there, this was one of the understanding that it will be reviewed. So it has to be reviewed and not as per the old rate, but as per the revised rate.
Okay,
they maintain that no, the rate cannot be reversed as per the new rate. It has to be in terms of the old rate. So the dispute took place even after this. Then I was also made to sign a supplementary agreement. Worships, that is at page 100.
So this will be an offer of agreement. This is an offer made. Did you agree to this?
Yes.
Okay, so there was a supplement agreement after that.
And this also became a part of the agreement, contract.
In which you signed?
Yes.
Yes.
132.
Oh.
Now, should I just read the operative portion, the relevant portion?
Yes.
Now, this supplementary agreement is as follows. This In this agreement, words and expressions shall have the same meaning as are respectively assigned to them in the condition of contract of the original contract signed on 22/8/2005 and after referred to. The following documents, in addition to the document listed at para 2 of the original contract signed on 22/8/2005, shall be deemed to form a part and be read and construed as a part of the agreement. So certain documents will also become part of the documents, and one of the documents is this letter that I just read, the previous letter. Now, Lordship, at page 33. So, 133, which are the documents which will become a part of the original contract has been mentioned. Construction, TL Construction request dated 26/9/2003 for out-of-court settlement. Rice letter dated 22/2/2017 regarding intimation of meeting. C. Contractors letter dated 1/3/17 for withdrawal of all suits against Rice to complete the remaining work as per terms and condition of original contract agreement dated 22/7/2005. Lordship, in this letter, that is at page, I have never mentioned, I had only mentioned that Lordship, back, I'm sorry, but may I kindly come to page 125 again. Lordship, in this letter, I said that at page 126, payment as per revised rate for additional three additional works awarded to me, white letter dated 26/9/11 may be made as mentioned in the said letter at the earliest. So I had asked for I did not agree to the old rate. I said it has to be revised in terms of the new rate. That was my request. While seeking for revocation.
So was that made a part of the agreement?
Yes, this letter is dated 26/9, 26/9, certified. 1/3/17. We have 1/3/17 letter. This letter has not been mentioned. This letter.
So this is where you're not agreeing, but that has not been made a part of the supplementary agreement.
Yes.
Oh.
Now, these were the parts of the document, so I signed this, and
so when you had put your signature, it has been repeatedly mentioned that it will be in terms of the earlier agreement.
Therefore, now all this, I'll come to that now. My case is on that only, whether I'm bound by this agreement, I have signed this.
Yes.
I've made it. Now, whether can this kind of agreement or contract be enforceable? That is the only issue. So, lastly,
If you were not agreeing that it should be based on the agreement dated 2005, then you should have not signed.
So, here,
because on and on in this agreement, page 133, they have referred to the contract dated 22/08/2005, even for the payment of your additional works, isn't it?
which one? Yes, Lordship, that is there. But here specifically, the interview contract letter. Now, Lordship, they just have included this letter, which is letter dated. This letter. 7/4. 7/4 money. 7/4. 7/4 letter is there. 7/4 letter, page 128.
128.
That letter is part of this contract. And what does it say? Number 2 say rates for additional work shall be reviewed. and will be paid as per original contract. So there's a mode of payment also. But the rates also will be reviewed. They have also said that. So I was under the impression that the rates will be reviewed.
Okay.
Reviewed
Yes.
in terms of all the
Original contract.
Original contract.
So now, so therefore we go back to the original contract.
You have stopped till reviewed, but they have traveled beyond reviewed.
Now, Lordship, that we go back to the
So original contract.
so, original contract. Okay. Okay,
Let's see the original contract because you have signed to
Yes,
that,
yes.
isn't it?
It shall be reviewed as per the terms of the original contract. That is mentioned at clause 7. Now, whether all this will be binding, because we go back to the original contract, everything goes back to the original contract now. Whether the terms and conditions of the original contract will be enforceable for a contract which was given to me in the year 2011, 12, which was not a part of the original contract. Just because I've agreed to certain rates in 2005, am I bound by that? Even if I made all this agreement subsequently.
But there was no separate contract for that, for additional work.
There was no separate contract.
Only you have been permitted
No,
to.
that is just a letter saying that do this work, and as per the revised rate, you do this work. Just that. Now, that was there. As per the revised rate, that said that in the letter by which I was asked to do the work, said the revised rate. But no separate contract, and subsequently, yes, they have written this as per original contract and have signed us. So this is basically my case. Now, Lordship, should I first take your Lordship to the impugned judgment order? That is at page 37. Before I do that, Lordship, may I come to the jurisdiction clause. Page, affidavit of the respondent number 3 to 5, page 105, 155. This is the affidavit. Page 157. Yes. 157. The second line. Further, clause 13.0 of section 1, instruction of tenderers of the contract agreement speaks about the court's jurisdiction. The said clause 13.0 is reproduced here below. 13.0 court's jurisdiction. Any suit or application arising out of any dispute or differences on account of this tender or any matter in relation to the award of the contract or for enforcement of the arbitration clause under the contract shall be filed in a competent court at New Delhi only, and no other court of any other district of the country shall have any jurisdiction in the matter. So, this is a clause which provides the jurisdiction of the court to adjudicate dispute relating to this tender. This is not an arbitration clause. Lordship, may kindly come to page 37 now, please, interim judgment and order, dated 9/4/2021. May I just read the relevant portion?
37.
Yes. May I read from page 50 onwards? Page 50, paragraph 23. Page 50. Paragraph 23. There seems to be only two issues in the present writ petitions, which are whether, in the existence of an arbitral agreement between the parties, that the High Court of Delhi alone will have the jurisdiction to try the dispute arising out of contract is enforceable in law, whether conscionable contractual agreement can be enforced in the eye of the law. 24. On the first point for determination, which is the matter relating to jurisdiction, where respondent in this writ petition has taken the plea that arbitral agreement stipulates the jurisdiction of Delhi will be the only court to have a decision on the matter is examined. The Arbitration and Conciliation Act 1996 under Section 5, which provides for, Your Lordship, this was absolutely not relevant. Then 25. This is clear that when arbitral agreement is in existence between the parties, the court normally do not intervene unless there are exceptional prevailing circumstances. The plea of the petitioner is that an arbitral agreement between the parties cannot oust the jurisdiction. This was not by plea. I was saying that the jurisdiction cannot be ousted by consent of the parties. It may be applicable in other cases. In arbitration cases, the court must always allow the process of arbitration to complete. The above settled law has been reiterated not only in the case of such and such, relied upon by the respondent, but also several other decisions of the apex court. Only when arbitration is complete and parties are agreed, the jurisdiction of the court begins. In our case, the arbitration has neither started nor concluded. The only fact that is brought before this court is that the first work was left incomplete as admitted by the petitioner in the bar. An inventory was prepared wherein the respondent were directed to pay 23 lakhs such and such. Whereupon the respondent of the deduction has paid such and such. Thereafter, the petitioner issued no objection due certificate. The contract dated 22/8/2005 was terminated. Again, in 7/4/17, contract agreement dated 22/8/2000 was revived, and 3 new additional works were granted. This was granted way back by law. This was granted in 2011. The petitioner claims that the works were completed and he has only been paid a sum of 21,59,322 out of the total contractual amount of 1.74 lakhs in the old rate. This claim he claims to be an unconscionable agreement. There is total denial of facts by the respondent who has submitted that the additional works were not completed. Here also is erroneous. There is a dispute with facts and figures. This claim and counterclaim. There is claim and counterclaim. This cannot be adjudicated by a writ court. Even if 2 arguments of the petitioner should be survived, the matter can be brought before a writ. The matter can be brought before a writ court, and also there is an leading of evidence which explains the hesitancy of this court indulges in the matter, controversy being of nature which cannot be decided less by proper leading of evidence. This court is of the view that the writ court cannot adjudicate into the matter. In view of the reasons stated, this court deemed it proper that a direction may be given that the matter be placed before the appropriate forum. Which forum? Now, it's not an arbitration clause. Even during one of the previous occasions on which his appeal was heard, the respondent number 3 has submitted a letter that there's no arbitration clause in the agreement. That's absolutely, and that was just a clause regarding jurisdiction.
Your prayer has been rejected on the ground of disputed question of fact.
There is 2 questions on 2 grounds, saying that there's an arbitration clause, so first we have to go there. And secondly, disputed question of facts. Now, which part is disputed? Additional work they have not disputed. They have paid the money, they maintained that they have paid the money in terms of the old rate. They never said that the works were not completed, so therefore we have not paid him. They're saying that we are paying him, but he's entitled to receive us in terms of the old rate fixed in 2005. So, because he has signed the agreement way back in 2005 and bound by that agreement now. So that is the only limited issue here. Whereas such agreement, if we go through the pleadings, where I've made a categorical statement of completion of the additional work, where I may say that payment has been made, there's no specific rebuttal at all. And when it's not rebutted, it's due to be admitted.
So the
issue.
Yes, the single bench did not decide on merits.
She said that the question is disputed.
Yes.
There's an arbitration clause, so first without arbitration we cannot come here. Which court cannot enter in the writ, and then disputed question of facts, because there's denial at but that denial has to be there in the pleading. An argument cannot be made which is not been pleaded. A case cannot be made up which is not traceable to the pleadings of the parties. Settled principle of law. They travel beyond the pleadings. So, Lordship now, whether, first point, they will also come here. They have repeatedly said that they have maintained their first argument, the first leg of their argument was that it's not maintainable because of the jurisdiction clause. Yes, the parties, civil dispute, the jurisdiction of civil court or maybe offset by by an agreement of the parties, between the parties, but not the jurisdiction. Actually, now, if I may just come to my grounds and supplement that with some decisions. These are the facts. If your lordship requests, then I can also go to the pleadings to show the specific pleadings which the parties have.
We'll hear from the respondents. We'll hear that from the
Lordship, I have not
respondents.
finished on the grounds.
Okay. No, I'm saying that point, that the respondents did not rebut the facts, that they can mention, isn't it?
Lordship, we kindly come to
Yes.
for the convenience of the court, I've just prepared a list of authorities and tried to call out the principles laid therein. The first one.
Too many.
And Lordships.
Too many. Too many case laws.
Yes, that's why for the convenience of this honorable court, I've just prepared this list of authorities. And Lordship may not, I've mentioned the paragraphs which I'm relying upon, and the principle that the ratio that I'm relying upon, so that you need not bother to read that thing is, everything is here. I've tried to call out the principles in brief. So the first one, Maharashtra Chess Association case, this judgment in 2020. It says, jurisdiction of the High Court under 226 cannot be offset merely by agreement of the contract or contract between the parties. The facts and circumstances of the case will decide if there's a public element involved. Now, Lordship, I'm saying there's a public element also involved. The right to be treated fairly. It's a government contract. A public element is always involved. Article 14 will be there. Right to livelihood also will be there. So therefore, jurisdiction cannot be offset merely by the clause 13 of the Contract Act.
Okay.
Then second one, number 2, Nasim Banu. So when the amendments made in my petition has not been controverted, specifically controverted, the amendment will be taken to have been admitted. I've categorically maintained in 2-3 places that I've been paid in terms of the old rate. And they, at one place, in paragraph 12 of their affidavit in opposition, they have said that the work has not been completed, general denial. I've also said that original work I have not completed, kitchen dining I have not completed. Additional, just general denial, not specific, no, the additional work has not been completed. That nowhere is there in the affidavit. And payment, they said they made it in terms of the old rate, as per the clause 12.1.2. Then again, same thing, number 3, an issue not traceable to the place of defense of the respondents in the counter is unsustainable. Now where the plea has been taken that this...
So in these, you are harping on the same points, isn't it?
Then argument beyond pleadings cannot be raised. Number 5 also same thing. Numbers
2, 3, 4...
5 also.
5. It's the same point.
Same points. Insofar as these are concerned, same points, then even if disputed question of facts, in some cases, under jurisdiction, if it involves public lemons, the Honorable High Court can go into it. These are number 7, 8, same thing. No bar for intentional repetition even if the same arises out of contractual obligation. So Lordship is well aware of all this. Now, this is number 9 and 10. 9 and 10. I banked my case on these 2 cases, particularly 9. I have entered into an agreement. I have signed the contract, well aware of the... They have also said in their affidavit, that I consciously signed the agreement, knowing fully well the contents of the contract agreement. Now, therefore, I cannot turn around and say I'm not bound by it. They have taken a plea. Now, this... Can we just read this?
Yes, this is the unenforceable clauses.
2013 AACC. C4. Paragraph 30. Paragraph 30.
Yes.
30, paragraph 30, where the action of an employer bear public character in content and element of public interest as regards the offer made by him, including the terms and conditions mentioned in an appropriate table, which invite the public to enter into a contract, such matter does not relegate to pure and simple private law dispute without the insignia of public element whatsoever, where an unfair, an untenable, or an irrational clause in a contract is also unjust. The same is amenable to judicial review. The Constitution provides for achieving social and economic justice. Article 14 of the Constitution guarantees to all persons equality before law and equal protection of law. Thus, it is necessary to strike down an unfair and unreasonable contract or an unfair or unreasonable clause in a contract that has been entered into by parties who do not enjoy equal bargaining power and are hence hit by Section 23 of the Contract Act. And where such a condition or provision becomes unconscionable, unfair, unreasonable, and further is against public policy, where inequality of bargaining power is the result of great disparity between the economic strength of the contracting parties, the aforesaid principle could automatically apply for the reason that freedom of contract must be bounded on the basis of equality of bargaining power between such contracting parties, and even though ad idem is assumed, applicability of standard form of contract is the rule. Constant or consensus ad idem as regards the weaker party may therefore be entirely absent. Thus, the existence of equal bargaining power between the parties becomes largely an illusion. The state itself or the state instrument cannot impose unconstitutional condition in statutory rules regulation vis-a-vis its employees in order to terminate service of permanent employees in accordance with such terms and conditions. So therefore, worships.
It's well enough, but before we go ahead, now the learned single judge has not touched upon this point at all. It has not looked into the merits of the case, whether it's unexecutable or what. So in the division bench at this stage,
of course,
I don't think we should look into this matter because it has not been dealt with. This is an appellate court.
Worship finds.
Yes.
There's no disputed question of tax. If Worship finds that
Yes.
there's no disputed question. Worship has found that there's no clause for arbitration. Worship is satisfied. Clause 13 is not a clause for arbitration. Worship is satisfied that because single judge held that there's an arbitration clause.
We will
Yes,
not tell you
but-
what we have decided,
No, what I'm
but
saying
that is your point.
Yeah, what I'm saying is there are 2 points on which merit was rejected. My petition was rejected. First was arbitration
Yes,
clause.
yes, on those two.
And arbitration
And not admitting, but supposing we agree to your submissions. Supposing we agree to your submissions, can we go ahead and decide on an issue which was not looked into by these things?
And let me
Yes,
take
yes,
the conversation over
yes.
court. If your worship has holds, I'm just assuming if your
If,
worship
yes,
holds
assuming,
that yes, there's no arbitration clause, so learned single judge was wrong there in rejecting merit on that ground, and there's no disputed question of facts with regards to the additional works and payment. So therefore, learned single judge also was wrong there now.
Yes.
Now, the question will come
Yes,
then,
whether we
whether
did
I'm entitled. Then this issue Lordship has to decide, because this was an issue before this court in the writ petition, and this writ appeal is a continuity of the writ petition.
but which was not touched upon.
That was not touched upon because he did not go into it, because before reaching there, he decided my case, rejected my case on other grounds.
You go ahead, we'll hear the other parties. After hearing the other party. anyways. But we'll hear you out. It's okay. Yes, please continue.
Lordship, on that point, it was there. This was my case before the suspension.
Yes,
He
yes.
just did not consider it
Yes,
because
yes.
he rejected it before reaching there. This need not be considered because I'm rejecting on these two grounds. Now, if these two grounds is found to be erroneous, then with due respect, Lordship have to decide because my case was that this contract, this agreement is unenforceable. Now, if Lordship finds that no, these two grounds were wrongly decided on these two grounds, now whether my petition will be allowed or not, that will become the issue. Whether then this ground has to be taken into consideration. And this appeal is just a continuity of the petition. Otherwise, the Lordship can decide that this was wrongly rejected and remanded back.
Yes,
again,
remanded back
to
to
the single judge to decide on
that. Yes, that is, I think,
That is-
an option if we agree to your submissions.
If
Okay.
Lordship agrees to my submission,
Yes.
then that option also will be there to remand it back and decide on the issue only, on the limited issue. Now, Lordship, these are my case. Now,
Yes. No, in the writ petition, his prayer was clear. What was your prayer in the writ petition before the single judge?
Lordship, can you come to my written petition then, at page 153, 53. 53, prayer portion is at 75. Page 75 is my prayer.
75.
Direct the respondent, this is the relevant portion.
Yes.
Direct the respondent, more particularly respondent number 3, 4, and 5, to pay the petitioner fund for the additional works, let's play field boundary wall, fencing, retaining wall, as per the revised rate, sanction by letter number such and such, that is such and such, and communicated to the petitioner by letter dated 1/6/2012. So, the new rate. That was my prayer. And they said, no, you're not entitled. They will go back to the old list.
Which was not touched upon by
This
the
was not touched
single
upon
judge.
because
Yes.
when a single judge thought that, no, there are other grounds on which the writ
Yes.
itself will not be entertained. It will not be entertained because there's a bar. I have not gone to the arbitration and there's disputation of facts. So the main issue which I raised, he did not enter upon it.
Yes. Anyways.
Now, Lordship, can I read one more?
Yes, go ahead.
1986, 3 SEC, 156. 89. Yes, skipping one. Lordship, may I read from page 215, paragraph 89. May I read? 89. Should then, of course, not advance with the times, should they still continue to cling to outmoded concept and outmoded ideologies? Should we not adjust our thinking caps to match the fashion of the day? Should all jurisprudential development pass us by, leaving us floundering in the slows of the 19th century theories? Should the strong be permitted to punish the weak to the wall? Should they be allowed to ride roughshod over the weak? Should the court sit back and watch spinely while strong trample underfoot the rights of the weak? We have a constitution of a country. Our judges are bound by the oath to uphold the constitution and the laws. The constitution was enacted to secure all citizens of this country's social and economic justice. Article 14 of Constitution guarantees to all persons equality before law and equal protection of the law. Principle deducible from the above discussion on this part of the case is in consonance with right and reason intended to secure social and economic justice and conform to the mandate of great equality clause under Article 14. This principle is that the court will not enforce and will, when called upon to do so, strike down an unfair and unreasonable contract or an unfair and unreasonable clause in a contract entered into between the parties who are not equal in bargaining power. It is difficult to give an exhaustive list of the bargains of this type. No court can visualize the different situations which can arise in the affairs of man. One can only attempt to give some illustration. For instance, the above principle will apply where the inequality of bargaining power is the result of great disparity in economic strength of the contracting parties. It will apply where The inequality is the result of circumstances, whether of the creation of the parties or not. It will apply to situation in which weaker party is in a position in which he can obtain goods or services or means of livelihood only upon the terms imposed by the stronger party or go without them. It will also apply where a man has no choice, or rather, no meaningful choice, but to give his assent to a contract or to sign to the dotted lines in prescribed or standard form, or to accept a set of rules as a part of contract, however unfair, unreasonable, unconscionable a clause is in the contract or form or rules may be. The principle, however, will not apply where the bargaining power of the contracting party is equal or almost equal. This principle may not apply where both parties are businessmen and contract is a commercial transaction. In today's complex world of giants corporation, with their vast infrastructural organization and with the state through its instrumentalities and agencies entering into almost every branch of industries and commerce, there can be married situation which results in unfair, unreasonable bargain where parties possessing wholly disproportionate and unequal bargaining power. These cases can be neither enumerated nor fully illustrated. The court judge must judge each case of its own facts and circumstances. Lordship, may kindly come to page 91. It is a contract of the type of mentioned above to be just voidable or void. If it was induced or by undue influence under section 9A of the Indian Contract Act, it could be voidable. If, however, really the contract of the type of which the principle formulated by us above are induced by undue influence and defined under section 16.1 of the Indian Contract Act, even though at times they are between parties of one of who holds a real or apparent authority over the other. In the vast majority of cases, however, such contracts are entered into by the weaker party under pressure of circumstances generally economic, which results in inequality of bargaining power. Such contracts will not fall within the four corners of the definition of undue influence under section 16.1. Further, the majority of such contracts are in standard or prescribed form or consist of a set of rules. They are not contracts between individuals containing terms meant for those individuals alone. Contract in prescribed or standard forms or which embody a set of rules are as part of contract are entered into parties with superior bargaining power with a large number of persons who have far less bargaining powers or no bargaining power at all. Such contract which affect a large number of persons or a group of persons if they are unconscionable, unfair, and unreasonable, are injurious to the public interest. To say that such a contract is also only voidable could be to compel each person with whom the party with superior bargaining power has contracted to go to court to have the contract adjusted voidable. This could only result in multiplicity of litigation which no court should encourage and could also not be in the public interest. Such a contract or such a clause in the contract, therefore, to be judged void. While the law of contract in England is mostly judgment, the law of contract in India is enacted a statute, namely the Indian Contract Act. In order that such contract should be void, it must fall within one of the relevant sections of the Indian Contract Act. The only relevant provision in the Indian Contract Act which can apply is section 23, which states that consideration of an or object of an agreement is lawful unless the court regards it as opposed to public policy. 92. The Indian Contract Act does not define the public policy or opposed to public policy. From the very nature of things, the expression public policy, opposed to public policy, or contrary to public policy are incapable of precise definition. Public policy, however, is not the policy of a particular government. It connotes more some matter which concerns the public good and public interest. The concept of what is more public good or in the public interest or what could be injurious or harmful to public good or public interest has varied from time to time. As a new concept takes the place of all, transactions which were once considered against public policy are now being upheld by the court, and similarly where there has been a well-recognized head of public policy, the court have not shirked from extending it to the new transaction and change circumstances and have at times not even flinched from inventing a new head of public policy. There are two schools of thought, the narrow view school and the broad view school. According to the former, court cannot create new heads of public policy where the matter countenances judicial lawmaking in the area. The adherents of the narrow view school could not invalidate a contract on the ground of public policy unless a particular ground has been well established by authorities. Hardly ever the voice of the timorous spokenly more clearly and loudly than English words of Lord Davy such as such. Public policy is always unsafe and treacherous ground for legal decision. That was in the year 1902, 78 years earlier. Protege in such and such described public policy as a very unruly horse, and when once you ride, you get astride, you never know where it will carry you. The master of laws of Lord Denning, however, was not a man to shy away from unmanageable horses, and in his words, we conjure up the very conjure up before our eyes the picture of young Alexander the Great taming such and such, in such as he said in such and such. With a good man in the saddle, the unruly horse can be kept in control. It can jump over obstacles. Had the timorous always held the field, not only the doctrine of public policy, but even the common law or the principle of equity would never have evolved. Sir William Hosworth in such and such has said, in fact, a body of law like common law, which has grown up gradually with the growth of nation, necessarily acquires some fixed principle, and if it is not maintained, this principle must be able on the ground of public policy or some other like ground to suppress practice which under ever new disguise seek to weaken or negate them. It is thus clear that the principle governing public policy must be and are capable of proper occasion of expansion or modification. Practices which are considered perfectly normal at one time have today become obnoxious and oppressive to public conscience. If there is no head of public policy which covers a case, then the court must, in consonance with the public conscience and in keeping with public good and public interest, declare such practice to be opposed to public policy. Above all, in deciding any case which may not be covered by an authority or our courts have before them, the beacon light of the preamble of the Constitution. Lacking precedence, the court can always be guided by the light and the principle of underlying the fundamental rights and the directive principles inside the Constitution. Lastly, my Lord.
Yes, so you're saying that this matter is also covered under public policy. Yes, okay, public interest is involved.
So
Yes.
I'm relying on 293 also. Should I read it or not?
Not really. I think you have made up your point. Made your point. We are-
So 93 also, I'm referring to 93. So therefore, Lordship,
But you have not challenged the terms of the contract.
No, I have not.
As of today.
Absolutely.
I think these are with regard to the terms of the contract. Unless you challenge it, how can the court do
Lordship says, you can read it down. It's not enforceable. It's not enforceable. That's what it said in the earlier judgment. I may not challenge it, but they cannot insist to bind me by such terms of the contract. That is my case. I did not challenge it, but cannot be made. I'm not bound by it. It's not enforceable. That's what I'm in the earlier cases. That's what I'm relying upon. So therefore, Lordship may kindly see 2005, certain terms rates are fixed. 2011, the rate of inflation these days, very in a place, Charlie, to some district, to execute it. And they showed me they gave me the approved revised rate too, along with the letter directing me to do the work. They showed me the rates. I do the work, when they pay me to the work. Is it fair? Can the state deal with a citizen in this manner? Unequal bargaining power, Lordship I may not elaborate on that. I'm just a mere conductor, a small fry, here the might of the state, trying to impose such an unreasonable, unconscionable. Can I be bound? Will the court just allow this to happen? That is my case.
Yes, okay. Yes, we'll hear the respondents. Who is there for the state to respond?
As far as respondent 1 and 2 are concerned, we're just formal respondents. This dispute is between the petition applicant and the respondent number 3, 4, and 5. So here I have nothing to say.
Okay. So respondent number 4 and 5.
Lordships. Lordships, they read I filed my written opposition, which is at page 155, running to field 1 and 4.
of the appeal, 1.5.
Hmm.
Respondent 3, 4, and 5 is highly affirmative opposition. Lordship, here we have categorically stated regarding the principal lordship at page 156, paragraph 4. We have a preliminary objection. Lordship, we come to page 156, which will be appeal, Lordship.
Yes.
Lordship, I will be allowed to review. Lordship. But before applying to the adjournments made by petitioner, it's submitted respectfully that the writ petition filed by petitioner is not maintainable before its own court. Therefore, the deponent begs to submit a preliminary objection in the matter as follows: that the office of the deponent has issued tender of construction of phase 1, package 2 building for JNV at Jari district, Pingsang, Nagaland, by order dated so and so and so. And being the successful bidder, the petition was awarded the contract by letter award dated so and so of dated 25/2005. After issuance of letter of award, contract agreement was executed with the parties by paying the requisite stamp duty as per the provisions of the Indian Stamp Act. There were several conditions in the contract agreement, and as per the state contract agreement, payments for the execution of the work will be made as per the conditions and specifications stated in the tender documents, and time of completion of the contract work was within a period of 10 months. Recount from the 10th day from issue of the letter of award. There was also a specific condition in the letter of award that time is the essence of the contract, and if the party fails to achieve the target work within the stipulated period of contract, the party shall be liable to pay compensation for an amount calculated at the rate stipulated in clause 2 of the general conditions of contract. Further, clause 13.0, section 1, instruction of tenders of the contract agreement speaks about the contract, a court's jurisdiction. They say clause 13.0 is reproduced in below. Any suit, court's jurisdiction. Any suit or application arising out of any dispute or differences on account of this tender or any matter in relation to the award of the contract or for enforcement of arbitration clause under the contract shall be filed in a competent court at New Delhi only, and no other court of any other district of the country shall have any jurisdiction in the matter, as is written from the state clause of the contract agreement made between the parties. Any suit or application arising out of any dispute or differences on account of the tender or any matter in relation to the award of the contract or for the enforcement of the arbitration clause under the contract, the same shall be filed with the competent court at New Delhi only, and no other court or any other districts of the country shall have any jurisdiction in the matter. As such, as per clause 13.0 of the contract agreement, the writ petition filed by the petition is not maintainable before some court. As such, the same is liable to be dismissed in the
It's totally misconceived. Totally misconceived. This totally, it's misconceived.
Lordship.
You read the 97 judgment, L. Chandra Kumar, and then this judgment. Or this, you cannot ask the jurisdiction of Article 226
Yes, Lordship. That,
and 32.
the fixed court is
So this is totally misconceived.
Lordship.
So I think we'll just stick to the other point
Yes.
made by the learned single judge concerning the dispute on the question of facts. Can you come to that straight away? Now, are you disputing on the question of facts that he has not? Now, the observation of the single judge was that certain works was not completed. Okay. But whether the second, the supplementary agreement or the later agreement, was it completed or not? I think that's the main issue, which you, are you saying that he has not completed that, what later? Because he admits that as per the first contract word, he has not completed the kitchen and the dining. That is not a disputed fact. Now, this the second part of the work.
Lordship, at the time of hearing the writ petition, Lordship, I've placed the letter dated 16/3/2021, stating that Lordship, I may be allowed to.
Yes. Is there a dispute on the question of facts?
Lordship.
We'll just come to that.
On this point, may I just clarify? Several occasions, times were given. Time was taken during the hearing. Even when the hearing continued, commenced, after that, times were given. And on the last day, this letter was produced. I don't know what is this letter. I also was given
Is it the part of the record?
No, it's
in
not
our
part of the
court?
record. That is my case, Lordship. That is my case. Anything which is not traceable to the pleading should not be taken into account. That's why I relied on all these cases. This was given, even that, but what is this? Also, I'm not sure.
If this wasn't made a part of the record in the before the learned single bench,
No,
then can we look into it now? I don't think so. It should have been if it was placed before the learned lower court.
Lordship, on the
Yes.
query with the undisputed facts. I placed this is dated the 16/3/2021, and the hearing was done on the hearing on the petition was done on 18/3/2021, and I placed on the 18/3. Lordship may see the column 4 and the status of the play field, boundary wall fencing, and retaining wall at annexure 6, page 30/31 of the petition. Play field not started, boundary wall fencing is not completed, retaining wall not completed. This is the status plea.
Very strange.
On this issue, the Leonard
Yes.
on this issue, the Leonard the single judge has asked that there's
Please,
disputed facts.
what's the observation?
This is of 2021. You have paid 21 lakhs, whatever may be, as per the old rate, as per the old contract,
Lordship.
original contract.
Lordship.
In 2013, yes.
This is 21 lakhs 55,000.
When? 2013.
13, yes. January.
But this letter says, this is of 2021, playfield not started, boundary wall fencing not completed, retaining was not completed. Is it your case that just because they have not, he has not completed, therefore you are not paying it? It's not a case. The case, your case is, though the additional will, the works which he has executed, the rate will be governed by the original contract. That's your only case.
Yes, Lordship.
By placing this letter, how could you have a different thing? This is of 2021 letter,
Lordship.
and you have paid it as per the old rate in 2013, amounting to rupees 21 odd lakhs. What is this?
And this has been this is made a part of the file in the lower court.
No,
So we can't not refer to this now. I don't think that would be appropriate. Huh? Maybe later. Yes. So you admit that there are no disputed question of facts as per the records in here.
This is you are placing it just to show that there is a disputed question of facts, which cannot be. Plus, moreover, you have not filed it. You have not brought on record. How can this be accepted?
Time of hearing, Lordship.
Should have been in the form of an additional affidavit or something. Then because this is an important issue. Anyways, any more submissions to make?
Lordship, as per the supplementary this thing, the agreement, Lordship. Lordship, we have page 133, Lordship. Lordship, the petitioner has also gone through these petition and Lordship. Question on the. I will be allowed to read, Lordship. Page 133.
Yes.
4. In consideration of the payment made to be made by the company to the contractor, as herein mentioned, the contractor hereby covenant with the company to execute, complete, and maintain the works in conformity with all respects with provisions within the provisions of the contract dated 22/18/2005. 5.
See, now as we had observed earlier, while the learned counsel for the appellant was making his submissions, Now, on the 2 points made by the learned single judge, the first one, we have already made it clear that the writ an appeal and a writ under 226, okay, cannot be ousted by an agreement. So that point made by the learned single judge will be set aside. The second one concerning the disputed facts also, since the evidence itself makes it clear that he has been paid 21 something lakhs for the completed works. Now, at this later stage, this which was not made a part of the file, it was not filed by you in the form of an additional affidavit also, which should have been done actually if it's something which is very pertinent. So we find that, having discussed the matter, that the writ appeal will be allowed to the extent that the judgment of the learned single judge will be set aside and the matter be remanded back to the single bench to decide on an issue which was not at all touched upon on merits of the case. Okay. Accordingly, we will dispose of this writ appeal and pass the order. Okay. Now, any other matter to be called up? Hmm. There's one more. Just call out. We'll see if they're there, if we're going to have it today or not.
For hearing, item number 15.
Are the parties ready for hearing
We are
today?
ready, but can this matter be taken up?
Yes, yes. Then if we are going to hear the matter after lunch, after 2, at 2 o'clock.
Two.
Yes.
Lordships, there is some recent development. There are 80 appellants who are landowners, and there is only one who is a bidder, one of the bidders.
Okay, bidders, huh?
Now, among the landowners, we are contemplating to withdraw the lead appeal. However, in view of involvement of so many persons, some consent could not be obtained.
Okay.
So, some time may be given, Lordship,
Okay, fine.
so as to arrive to a conclusion.
So this
And
is the
moreover,
bidders,
there is no stay order also.
Okay. Oh. So we'll adjourn the matter. For how long do you want it?
3 weeks, Lordship.
Bidder will continue the writ appeal.
Will the bidder continue? You said there's only one bidder. Will the bidder continue or no? Who has filed the writ appeal?
Not likely to continue.
Okay, then it's good. Mr. C.T. Zamir, Learned Senior Counsel for the appellant, who submits that there have been some recent developments wherein it could be possible that the appellants might consider withdrawing the writ appeal. He has therefore prayed for adjournment of the matter. Yes, then Mr. Desingira, Learned Senior Counsel for the respondents is present. In view of the above submissions, dismiss this matter after 3 weeks. Yes. That's all.
Kau tahu apa?